Hello, this is beginning of our fourth seminar online in the module of Fight Against Corruption. Out of 3 participants, we have only 1, right, Farid?
Yes, I can hear you.
Yes. What about other participants? Have they been informed of this lesson? I
The one
sent
part.
invitation on through these teams.
Okay, I thought is not joining with us because has internet problems, but I don't know why Rovshan didn't participate.
Okay. Anyways, this is fourth seminar. Um, you received questions in advance, right? And our
Yes.
topic today is fight against money laundering in the context of fight against corruption. Can you hear me?
Yes, I can hear
Okay.
you.
Yes. Would you like to pick any question?
Um, Questions.
Yes. Among
Just a
5
minute.
questions, I give you a chance to choose any question.
Um, I I'd like to answer second question. Instruments, international arrangements.
Read the question, please.
Okay, bir saniye. Just a minute. Explain the international institutional and regulatory arrangements to describe international anti-money laundering efforts, refer to the international institutions and mechanism, and describe their roles.
Okay, please go ahead.
First of all, I want to say that the history of money laundering term goes to back last century, 20th century, and the terms is the history of these terms related to the name of Al Capone, and in those times Al Capone uh, earning a lot of dirty money or illicit obtaining in the results of criminal activity. And during 7 years, Al Capone owns 100 million dollars, and the amount is equal to now 1.400 billion dollars. But Al Capone was prosecuted for tax evasion crimes because in those times money laundering crimes doesn't exist in the criminal code of Chicago. And also the history of money laundering, also developing or improving of money laundering, is related to institutional or international arrangements, international measures, and also legislative measures. And majority elements of this crime of this crime is of these crimes is reflected in international legislative act or international convention. First of all, the international arrangements is related to some convention, some international convention, and some international convention are included. That the Merida Convention, namely United Nations Convention against Corruption, dated to 2050 years. The next convention, Palermo Convention, namely United Nations Convention against Transnational Organized Crimes, dated 2011 years, and then other convention, for example, Strasbourg Convention is the main convention fighting against money laundering, and namely uh, Convention on laundering search says a confiscation of proceeds from crime, from crime, dated 1990, and the next convention is Warsaw Convention, namely laundering search, Convention on Laundering Search, seizure, confiscation of proceeds from crime, and also on financing terrorism, dated 2005 years. Also, there are also additional convention in the field of anti-money laundering activity. The convention is related to United Nations Convention on Financing Terrorism, dated 1999. Also, declarative of European Parliament and Council, namely prevention for the use of financial institution for the purpose of prevention money laundering and financing terrorism, and also the anti-corruption, anti-money laundering activity is related to some initiative or institution. For example, Basel Committee on Bank Supervisory and Egmont Group, Financial Intelligence Unit, and also Financial Action Task Force. The one initiative or organization in the field of anti-corruption, anti-money laundering activity is Financial Action Task Force. This is international intergovernmental organization, and this intergovernmental organization was established in 1989 years, and the main purpose the main purpose of this organ is to take measures on the preventing and detecting anti-money laundering activities. But in the 2001 years, the purpose of this organ is expanded, and the prevention of measures against financial terrorism are reflected in the purpose of this organ. The main organ in the field of anti-money laundering is Egmont Group. The Egmont Group was established in the 1995 years, and also the main purpose of this organ is to create a platform to collect or obtain information related to money laundering or financing of terrorism. And also financial intelligence unit is the main organ in the field of anti-money laundering, and financial intelligence unit itself is a national service, and also the main countries, I think majority of world countries has financial intelligence unit, financial intelligence unit, and the financial there are many forms of financial intelligence units, and there are many models of financial intelligence units. Models of financial intelligence units is including administrative model, judicial model, and law enforcement model, and hybrid model. And hybrid model also contains both of administrative model and law enforcement
No,
model.
this is not the subject of our today's seminar. We are not looking into the models of FIUs. We are looking at the international arrangements. International arrangements in the form of instruments and in the forms of international institutions. You described these institutions and instruments. It is important that you understand that you can discern, okay? Maybe you do not remember the name of each of the institutions or of these instruments. It's important that you have this knowledge structured in your head, right? So that in the future you'll be able to navigate through this information. So when we speak about international instruments, one point that we have to realize is that money laundering issue, it was born in the field of fight against drug, correct?
Yes.
So everything, it started actually, this entire work in a systematic way, in a continuous way. It started in the field of fight against drugs. And the United Nations Convention in this field, in the field of
Illicit or narcotic
fighting
drugs.
against illicit traffic of drugs, it was the first step, right? It was the foundation of fighting against money laundering. Even in Azerbaijani legislation, if you look back at the time when we started to criminalize money laundering, we started with these with the offenses of illicit traffic of drugs. And first predicate offenses in this field, they were illicit drug trafficking offenses related to the traffic of drugs. Gradually, this field started to expand. And we saw the expansion. It was not only at international level, it was at the level of United Nations and at the level of regional levels. So in the European area, where Azerbaijan also belongs to, Council of Europe acted as a forum for developing of two important instruments in this field. First one was adopted in 1990, correct?
Yes.
Strasbourg Convention. And then after a certain time, this Strasbourg Convention was revised. The countries and the systems, they perceived necessity to upgrade, renew the provisions of Strasbourg Convention, so they adopted a new convention, Warsaw Convention. Okay.
2005 years.
Sorry?
2005 years adopted.
Year 2005.
Yes.
Year 2005. So part of this convention, it upgraded the previous convention, and to a certain degree, accordingly, they remain. The two conventions, they remain. The 2005 convention is wider in scope, right? It also, among others, are you here with me? Okay.
Yes.
Along with other issues, it also expanded into the field of countering the financing of terrorism. So at the European level, we have these two conventions. At the United Nations level or international level, we have first this UN Convention Against Drugs. Then it develops further into the field of transnational organized crime, into the field of financing of terrorism, into the field of fight against corruption. So it's like a big tree which starts with this, with the trunk of fight against corruption, with predicate offenses being only the offenses in the field of drugs, right? And then the list of offenses, the scope of predicate offenses, it starts to expand and cover all crimes which generate profit, including terrorism financing, and the latest newcomer, which is proliferation, right? Counter-proliferation measures are also covered through this field. Okay, in the field of institutional arrangements, you kept mentioning these institutions and saying that they are the main institutions. We cannot say that any one of them is the main and others are not main, okay? You mentioned Egmont Group. Egmont Group is a platform, is a framework for cooperation of FIUs, Financial Intelligence Units, which it depends on the country which model they choose. It can be either FIU or the Financial Monitoring Service, as in Azerbaijan, right?
Established in 2019 years by the 66th decree of the Republic of President of the Republic of Azerbaijan.
Okay, now you're mentioning now the establishment of the latest model of FIU in Azerbaijan, right?
Yes.
FIU was established long time ago. It just changed, its structure changed, its nature changed, right? It moved from various authorities. It used to be independent. It continues now its autonomous independence under the Ministry of Economy, right? The latest development. So we're speaking now about international arrangements. So the international framework for FIU cooperation is Egmont Group. Okay, so also we said that in addition to the the international actor which represents these specialized national anti-money laundering agencies, there are also other international regulatory actors, right? Which issues international guidelines and norms for various sectors of financial activity. In the field of banking, this is Basel Group, right?
Basel Committee.
And also we have this different group for insurance activities, correct?
Activities.
And also we have a general standard setter, the initiative, the system, or organization you may call it, which sets the standards for the entire money laundering activity, and this is FATF, the Financial Action Task Force, with their headquarters in Paris in the building of the OECD, Organization of Economic Cooperation and Development, which sets the standards through so-called recommendations. And although they are called recommendations, they are much stronger in effect, right? Because if the countries fail to perform these recommendations, they will see the financial consequences. So in brief, you mentioned all these elements. It just was important to make it structured for you. I hope now you can imagine very clearly and in an explicit manner the structure of this international regulation of fight against money laundering. We by no means can go into the depth of this topic under this module because it's a huge topic. It merits its own module, and therefore here we'll stop. So is there, which second question would you like to pick in order to answer?
Just a minute. Last question. What, in your opinion, is the rationale beyond introducing the concept of other persons involved in monitoring, and who are these?
Okay, so this is the topic of when we switched from a criminalization heading into the heading of prevention, right?
Yes.
It's the second big topic that we're going to cover under this module. So we are speaking now about the prevention of money laundering. Go ahead, please.
First of all, I wanted to answer the monitoring system in the field of anti-money laundering activity. A monitoring system is carried out by monitoring organization or main monitoring organization. Also, the main purpose of this monitoring organization is to create a platform related to obtain and collect information with the laundering activities or financing terrorism in the result of criminal activity. And the monitoring system is based on some information with the property information and dirty money related information in the result of criminal activity, and also receive the information with the from the other persons or legal persons, including monitoring entities or other sources also including the persons who are involved in this process, and the one of the persons is who involved in this process, and who involved in this process must be engaged in purchase or sale of precious stones or precious metals, or jewelry or other some goods made of stones and metals, and also the person who involved in this process engaged in sales in the purchase or sale of real property, real estate or real property, or uh, uh, real or lottery, and also the persons who involved in this process engaged in the process is including following persons: sport organizers, lawyers, notarius, or the persons who provide to function, to provide to tax function, accounting function, consulting functions, and also audit service functions.
Okay, what you just did, you tried to speak about this monitoring process. Okay, you mentioned several times, is it as organization, then as process, then as a system. Monitoring is the process, right?
Yes.
Fight against money laundering in Azerbaijan is built on the concept of monitoring in the field of prevention of money laundering. And through this process, the competent national authorities are obliging and collecting necessary information from the actors when they come across the instances of money laundering. So the competent authorities are setting up flags, the mechanism for reporting. And reporting is an essential part of monitoring system. Monitoring system is composed of organizations, actors, competent national authority, and their different obligations. So it's a system. According to this monitoring system built in Azerbaijan, the main institutions subject to monitoring, right? And they are financial institutions.
Yeah.
They are banks, right?
Non-bank financial institutions.
Sorry?
Banks, non-bank financial
Non-bank
institutions.
financial institutions. So we realized that main actors which are subject to the rules of this monitoring are banks and non-bank financial institutions. So the question which I formulated for your seminar was, what was the rationale for introducing this concept of other persons? You mentioned several of them, right? Like dealers in precious metals, dealers in precious stones. You didn't mention them all though, okay? You mentioned auditors. You didn't mention the lawyers.
Notarius.
Right? Notaries. So what was the rationale? What is the rationale for the legislator for this national system beyond to introduce these new actors beyond these banks and non-bank financial institutions and main subjects of monitoring? What is the rationale? Why was it necessary to introduce them? And what was the necessity and why they introduced it in this form? Okay, this answer to this question doesn't come exactly from what I record in my lectures, right? It shall be based on the result of your analysis. So what is the rationale, the reason why the legislator introduced this additional category?
Because I think that the main purpose of the money laundering activities must be the prevention and to taking measures the prevention and detecting of anti-money laundering activities in the field of anti-money laundering, and I think that that's why legislative introducing the another persons who involved in engaged because I think that
Okay, listen. So imagine when we speak about money laundering, what we are speaking about primarily is the risk, right? The risk that illegal money, illegal assets will enter legal economy, lawful economy, correct?
yes,
And this risk is it increases in the field where money is concentrating. The more money, the greater risk. Okay, so we know that money accumulates, assets accumulate greatly in the first turn in banks. In banks, they accumulate money, right?
yes,
So the first spot where the money will accumulate in vast quantities is bank. Then there are also other institutions which have lesser money perhaps, or sometimes they can have more, but usually they have lesser money. These are non-financial, non-bank financial institutions, right? But the scope of these money concentration spots, of risk concentration spots, is not limited to banks and non-bank financial institutions. There are also other actors in the market who are handling big amounts of assets and money, right? And that's why the legislator, he knows that in addition to banks, non-bank financial institutions, there are such professions and businesses which are dealing with big amounts of assets or money. And this could be lawyers who are engaged in investing of money, who are engaged in real estate operations or other sales and purchases, right? This could be notaries who are formalizing these purchases, big purchases and contracts and real estates, for example, sales, and other like dealers in precious metals and precious stones. So essentially, this additional set of actors, they're not subject to the same regulations as the actors from financial sector, like banks and non-bank financial institutions. They have their own system of regulation, not as strict, for example, as bank requirements, but still they are posing a great risk. If uncontrolled, if unchecked, they will be generating risk in the field of money laundering. So that is the rationale why they were introduced into this domain of monitoring in the first place. But they were introduced separately because they have different set of regulations. They have different set of regulations which make them different from these banks and non-bank financial institutions. And that's the rationale which is beyond the introduction of these actors. Okay, I can't see you, your camera is switched off. Today we covered 2 out of 5 questions. I really regret that other students, they were not able to come in. Despite several efforts, I informed them through their Teams messengers, and you informed them, right? Did you inform them? Did you speak on the phone
yes,
or?
I on the iTouch and Roshan also.
Okay. When I started this, before recording this meeting, I attempted to involve Ravshan, but he joined and then left the.
Unfortunately, he didn't participate in our lecture, but I don't know why he didn't participate in our lesson seminar.
Okay, thank you for your time for participating online at our online seminar. This is the end of our seminar, and we'll make another seminar in a week.
Okay, bye
Thank you.
bye. Goodbye. Have a
Bye.
nice day.
You too.